with the technical problems, you might want to log out and try logging back in as well. If you continue to have problems getting back on, please call iLink support at 800-799-4510. Katita, if you could put that in the box, which you just did, thank you very much. Oops, that's a call-in number. Oh, wait a sec. There you go. Thank you very much. And my assistant, who's already been doing stuff for today's webinar, is Katita Cavero, and I just want to thank you for your help, Katita. You'll find the chat box at the lower left-hand corner of your screen. To use it, just put your cursor in the white rectangle at the bottom box there, the bottom triangle. Click in there so your cursor, you can see that your cursor is in there. Enter your text and then hit the Enter key on your keyboard to submit. So why don't we all go ahead and try it right now. Try out the public chat. So go to the public chat tab there. And if you could let us know where you're calling in from, where are you joining us from today? And if you could also let us know how many people are at your site if you're joining as a group, that would be great. Welcome, Miami, Iowa. So if you look down there, you can see where people are calling in from. Great. That's terrific. Thank you, guys. And if there's more, some of you are telling us if there's more than one person, how many people are there. That's really helpful. Thank you. As you probably figured out, all participants are muted. So please use this chat feature. Use that chat box if you have any questions, problems, or comments. We'll collect questions during the webinar, and if time allows, we'll pose as many as we can to our presenter at the end of her presentation. And if you have technical problems, you can give me a private chat. If you go to the right of the public chat, you'll see a little tab there. My name is Sue Osthoff, and you can send me a message. Hopefully that feature is working today. There's been some glitches with iLink in recent webinars, so I hope that is working. And if you're on phone only today, you can email me with questions at suo@ncdbw.org. I'll repeat that. It's suo, S-U-E-O, @ncdbw.org. My email, you have it from the emails this morning. And either I or one of my coworkers will do the best we can to get back to you. We are recording this webinar today, so you'll be able to access this on our website, which is www.ncdbw.org. And hopefully you'll be able to access it in about a week. We've also posted today's PowerPoint version. It's a PDF version, so you can save it or print it, unlike the one that you're seeing on your screen now if you're signed in through iLink. We've also posted the presenter's bio and a couple of handouts that she gave us to share with you. The link was in the reminder note that you got this morning, but Katita, if you could also put it up there today in the chat box now, that would be great. And if you're signed into iLink, you don't need to get the PowerPoint from Google Docs now. You can get it later. Katita, do you have that link? There you go. Thank you. Also, shortly after the webinar is over, you'll get an email from me, and it will contain a confirmation of your attendance, a link to the recording, our posted recordings, it's a link to our website, and a very brief survey. And if you could take the survey, it would be really helpful. Your feedback is very, very useful to us and to the people who present as well. Right now, we're going to actually, let me go back here. Right now, we're going to ask you 3 short questions. And this is also information that's helpful to hear, for us to hear from you about. So here's the directions about the polling questions. Unfortunately, we can't have both these directions up and the questions. So let me go see if I can pull up the questions now. Okay. So I'm going to put all 3 questions up on the screen now. What we'd like you to do is to actually, let's see if I can get them. Sometimes we have some difficulty with this. So right now, you should be seeing on your screen, how do you describe your profession? I hope you're seeing that. And if you can answer there, for those of you signed in on iLink, right there on the screen, go ahead. If you're a community-based advocate, that dot immediately to the left of where it says community-based advocate, if you can just click in that dot, that's terrific. It's very helpful. We've unfortunately been having a little difficulty with these polling questions. Let's see if they come up. We'll give it another second. And if you check other, if you could tell us in the chat box what your profession is, that would be helpful. Unfortunately, the other polling questions are not coming up. Katita, are you seeing them, or are you only seeing the first one? Or Kathleen, maybe you can tell me, because I'm not seeing Katita respond there.
I'm sorry, what's the question?
Are you just seeing how do you describe your profession?
Yeah, that's all I see.
Okay. So since we're not seeing the other ones, if you are an OVW grantee, if you could quickly put in the chat box that you're an OVW grantee and what kind of grantee you are. If it's a REST grantee or a LAV or a state coalition or STOP, tribal DV and or sexual assault coalition or other, that'd be really helpful. And we'll just give that another minute, and thank you for your patience. And Kathleen, are you seeing that, the answers, and others as well, the answers of how people describe their profession? So you can see that the vast majority of community-based advocates. Okay. All right, thank you for those of you who are answering the questions about being an OVW grantee. We really appreciate it. That's very helpful information. Okay. For those of you who joined a little later, because now we're up to 61 people who joined after we started, I'm Sue Osthoff with the National Clearinghouse for the Defense of Battered Women here in Philadelphia. And I want to extend a warm welcome to you, and thanks for joining us today. This is the 5th in our series of webinars about when survivors reenter their communities after jail or prison. And if you missed the other webinars in the series, the recordings of the first 4 are posted on our website, which is at ncdbw.org. Katita could put that in the chat box. That would be great. And when you start listening, you have to sign in kind of like you did today. And when you start listening to the recording, it actually pulls up the PowerPoint presentation. So you'll have access to the whole presentation. We also include links to the Google Docs, so you can also then print out the PowerPoints if you want. So you go to our website at ncdbw.org and then go to resources. And please watch your email for announcements of future webinars in this series. The next ones we have scheduled are in September, and information will be coming out about that at the end of August and the beginning of September. You've probably noticed all the participants are muted. As I mentioned earlier, we will collect questions during the presentation, and time allowing, we will ask as many of those questions as we can to Kathleen, our presenter, at the end of her presentation. So you can ask those questions down in the little chat box in the lower left corner of your screen. So, as you're probably aware, today's webinar is titled, When the Battered Mother is Incarcerated, Impact of the Child Welfare System. And it's a real pleasure to get to introduce our speaker today. In an effort to save time, I will do a brief introduction, but we've put her whole bio up there on the PowerPoint. I'm sorry that the writing is a little small. We have also posted a copy of that on Google Docs if you want to print that out. Briefly, Kathleen Creamer is a staff attorney at Community Legal Services, which is here in Philadelphia. And she's devoted her career to working with parents and children involved in the child welfare system. Kathleen just recently completed a 2-year fellowship with the Stoneleaf Foundation. As a fellow, she did policy work to improve services to children and families of incarcerated parents. Prior to beginning her fellowship in May 2011, she worked as a staff attorney at the same very excellent legal services organization where she works now. And in that capacity, she represented parents, including those who were incarcerated, in all stages of dependency proceedings, including adjudication, permanency reviews, termination of parental rights trials, and appeals as well. Before that, Kathleen was the Director of Legal Services at Our Place DC, a program that provides supportive services to women during and after incarceration. And for those of you who participated in our last webinar, you may recognize the organization since it's where our presenters, Courtney Cross and Katrina Cheshire, worked. Kathleen has so much valuable experience, and I know she has a lot of information to share with you today, so I really want to turn this over to her as quickly as possible. But before I do, if you're having trouble connecting or other technical problems, try calling iLink support at 800-799-4510. Katita, if you could type that in again. And if you have other questions, please type them in the chat box in the lower left-hand corner. If you are listening in only and have questions, feel free to email me at suo@ncdbw.org or call us at 215-351-0010. Kathleen, thank you so much for your really great and important work, and thank you for your willingness to share it with us all today. And so without further ado, I'm going to turn it over to you, Kathleen, and you have control of the PowerPoint now.
Okay, great. Thank you so much, Sue. Just again, my name is Kathleen Creamer. I'm currently a staff attorney at Community Legal Services of Philadelphia, where I represent incarcerated parents all the time. And if you can't tell from my bio, my passion is absolutely working with incarcerated moms. I just completed a 2-year fellowship in Philadelphia, really geared at looking at how we provide services to incarcerated parents when their child is in foster care, both in Philadelphia and across the state. I'm so excited today to see so many of you from across the country. It's really exciting. I obviously have a lot of specific experience with Pennsylvania, but this presentation is geared towards a national audience. What I really want to focus in on today is what federal laws and what state laws tell us about incarcerated moms and their children. And what the mom's rights are and also what their responsibilities are when they have a child in foster care. So I'm going to start, and I also wanted to say, I wanted to mention that I will take time for questions. I'm going to be talking about the law a lot and showing you statutes, and I know it can get confusing. I'm going to try to go as slow as possible, but I'm also going to try to stop periodically and make sure everyone is with me. And if you do have questions, I'll let you know when it's a good time to type them into the chat box. So I want to start by kind of talking about who are these incarcerated mothers and what do we know about them. The reality is that we don't know enough. We know way too little. There's not great data collection about women who are incarcerated, and there's really terrible data collection about children of incarcerated parents in this country. So in a lot of ways, we're kind of at our infancy in terms of gathering data and really trying to understand the experiences of these families. It's been kind of an exciting time for me to be working on issues regarding children of incarcerated parents because many of you may have heard that in the last month or two, there's been a lot of national attention about children of incarcerated parents because Sesame Street just launched an online toolkit and actually created a Muppet whose dad is incarcerated. So I highly recommend everybody go to sesamestreet.org and take a look at those materials. They're very good, and it's been nice to see the White House kind of follow step of the lead of Sesame Street and start to think about how our policies are impacting these families. But as I said, we're kind of just getting started in this frontier. So I'm going to start and talk about what do we know about incarcerated moms. We know that women who are incarcerated are moms. We know by and large that the vast majority of women who are incarcerated are mothers, do have minor children. And we also know that these moms are uniquely at risk for child welfare involvement. As many of you know, a lot of moms who end up incarcerated were the primary caregiver for their child prior to their incarceration. That's often not the case with dads, less often the case with dads. So women who get incarcerated are actually very uniquely vulnerable to child welfare involvement. What our data does show kind of about these families is that if dad goes to jail, the child lives with mom. If mom goes to jail, the child lives with, fortunately in most cases, a relative. But if a relative is not available or for some reason a placement falls through, these kids are uniquely vulnerable to ending up in foster care. And we also know that women who are incarcerated, in addition to being moms, are also very likely to have experienced domestic violence, either violence that precipitated their arrest and incarceration or violence that has a very distinct impact on their life when they get out or before they went in. We know that about half of all female inmates report having been victims of domestic violence, but my guess is those of you who work with women who are incarcerated know that that number is a significant undercount. My personal experience is that the vast majority of my clients who end up incarcerated have experienced domestic violence in their lives, and my guess is your experience is very similar. So battered women who become incarcerated are uniquely vulnerable to child welfare involvement because they have two factors going against them. They have the factor of being incarcerated, and as I said, women who get incarcerated are way more likely to be child welfare involved than dads. And also because they have this history of domestic violence, which often hurts them in their child welfare proceedings. So what do we know about the kids? We know that the number of children of incarcerated parents in the country is incredibly high. The Pew Charitable Trust estimated about 2.7 million children right now have an incarcerated parent. So that number, while it's a very dramatic and large number, actually excludes all the children who experience parental incarceration in their life. The 2.7 million number is actually just a snapshot. It's just a moment in time for these kids. So we have a lot more kids who have had an incarcerated parent at some point during their childhood. Right now, we know we're in the middle of really an epidemic in terms of the rate at which we incarcerate people. As you all probably know, the United States is the leading jailer in the world. We incarcerate more of our citizens than any other country in the world. And currently, in the United States, 1 in 100 adults are in jail or prison. There is absolutely a disproportionate racial impact in the way that we arrest and incarcerate people, and that shows in results for our kids. So we know that 1 in 9 African American children have an incarcerated parent, and 1 in 28 Hispanic children have an incarcerated parent, while only 1 in 57 white children experience this. As we discussed, most incarcerated parents are dads, right? So our prison population is largely composed of men. Over 90% of people in jail are dads. But it's really important to recognize the experience of women who are incarcerated because their numbers are growing really dramatically. And in fact, women are one of the largest growing demographics in prison, and they're outpacing men for rates of incarceration at this point. So from 1991 to 2007, the number of incarcerated mothers rose by 131% compared to a 77% increase in dads. Most parents are incarcerated for nonviolent offenses, but that is especially true of moms. Moms are by and large nonviolent offenders. And I think this last statistic is really important because it really kind of, to me, busts a myth about these parents having been absentee parents prior to their incarceration. The reality is that most kids lived with their parent before incarceration, and that is really true of moms. Most kids of incarcerated mothers lived with their mom right before their mom got incarcerated, and about half of kids of incarcerated dads lived with their dad before incarceration. As I discussed a little bit earlier, the impact of children of maternal incarceration is a little bit different than the impact of a father's incarceration. So we know the data is really clear that when incarcerated dads are in the picture, when children have an incarcerated dad, they usually get to live with their mom during their incarceration. They don't end up entering the child welfare system. We also know that most children of incarcerated parents, when mom gets incarcerated, don't live with their dad. Most of them live with a relative. The issue becomes for a certain number of kids that some of them don't have a dad or a relative available to care for them when mom gets incarcerated. And as a result, we're guessing around 10% of children of incarcerated parents end up in foster care. We don't have great data about this, and we know that the number really impacts moms way more than it impacts dads. So 11% of incarcerated women and 2% of incarcerated men report having a child in foster care. Again, it's really important to note that our data is terrible on this, so these are estimates. But this is what we know so far. It's been interesting to see the federal government start to pay a little more attention to this issue. So we know that we have a large number of children who entered foster care due to a parent's incarceration, but we don't know how many because our data is really terribly maintained. And I urge any of you who are interested in this issue to take a look at the USGAO report because it really kind of delves into why our data is so bad on children of incarcerated parents in foster care and what we could do to make it better. But we know right now we have a number of 8% of children in foster care are there due to a parent's incarceration, but that 8% is absolutely an undercount. And the GAO kind of said, we know this is bad data. We know 8% is kind of just the beginning. The numbers of children who are in foster care because of parental incarceration is actually much higher than 8%. And we know that at least 14,000 children are represented by that 8%. So I'm going to just stop really briefly to make sure nobody has questions kind of about the larger data picture before I really get into how our laws kind of address the issues surrounding children of incarcerated parents when they enter foster care. I'm just going to take 1 minute and check the box just to make sure nobody has any questions.
Kathleen, this is Sue O. While people are seeing if they have questions or typing in their questions, you said that the number 8% of kids in foster care due to incarceration is woefully an undercount, a huge undercount. Do you have an estimate of how many you think might be in foster care due to incarceration?
You know, it's a really interesting question, and I actually, as part of my Stoneleigh Foundation Fellowship, did a major data mining expedition in Philadelphia to get a handle on the numbers. And in Philadelphia, we found at least 13%, but as many as 20%.
Wow.
So somewhere between 13 and 20%. So, and the data that Philadelphia maintains is not great either. And we knew when we were looking at the data that we were missing a lot of kids. So if I had a guess, I would guess it's closer to 20%, closer to 1 in 5.
Wow.
But we don't. Again, we're keeping such terrible data.
Okay. It looks like there aren't questions, Kathleen, at this point. So if you want to keep going, terrific.
Yeah.
Thank you.
So what I'm really going to spend some time right now talking about is what happens to the child of an incarcerated parent who enters foster care, and what do our laws say about the rights of the parent and the experience of the parent and child during their stay in foster care. So I think a lot of you are probably familiar with the Adoption and Safe Families Act. The Adoption and Safe Families Act, you've probably hear it referred to as ASFA, is kind of the seminal and controlling statute in federal law on child welfare. It was enacted in 1997, and the goal of ASFA was absolutely very laudable. ASFA was intended to end foster care drift. Foster care drift is kind of the consequence of laws in various states that allowed children to kind of remain in foster care indefinitely without any kind of clear plan for how they're going to get out of foster care. So, recognizing that was bad, ASFA set about kind of remedying that situation by passing federal legislation that tied federal funding to every state accepting their regulations around child welfare. So at this point, ASFA has been adopted by every state in the United States. And really the goal of ASFA, as I said, was really to kind of make a plan for kids. Make a plan for kids as soon as they get into the foster care system so that we're not kind of losing them in foster care indefinitely. We know research is very clear. Foster care in general is not good for kids, and extended stays in foster care are associated with particularly bad outcomes for kids. So ASFA decided to establish a really strict timeline for how long are we going to keep kids in foster care. And I think that's kind of the hallmark feature of ASFA that everyone should be aware of, and that I actually make sure all my clients are aware of, is that ASFA creates a timeline for parent-child reunification. ASFA says that, and I'll show you the next slide. ASFA says that the timeline for parental reunification is 15 months. So essentially, if a child is placed in foster care, the parent has 15 months to reunify with the child. They say 15 out of the last 22 months because sometimes we have cases where children return home briefly but then end up going back to the parent's home. But in general, it's a 15-month clock. So once a child enters foster care, the clock starts ticking. And 15 months, as many of you know, is not a long time to get your child back. And especially, it's not a long time if you are incarcerated and facing a long sentence or even a long trial and hearing process. There are some exceptions in ASFA to the 15 out of 22 month rule. The exceptions are that the child is living with a relative. I should say that these exceptions are permissive but not mandatory. So there may be cases where a child is living with a relative and yet the Child Welfare Agency decides that adoption is in the child's best interest. They're well within their discretion in most states to go ahead and file anyway. Another exception to the requirement is that there's a compelling reason that TPR is not in the child's best interests. And the last exception is that children and youth has not provided adequate reunification services. So this is the language in the federal statute. So this has been adopted by every state in the country. I want to make sure everyone is aware that your state may have different laws. It will include the 15 out of 22 month timeline, and it will include these exceptions, but some states have other exceptions that they recognize, and I'll talk about that a little more later. And then some states also may have a shorter timeline for reunification. I've seen some states that really have a 6-month timeline for reunification or a 12-month timeline for reunification. So 15 out of 22 months is kind of the outside requirement that ASFA establishes, and states were kind of left to create their own statutory frameworks around compliance with ASFA. So ASFA also laid out what is called the permanency hierarchy. So in order to get to the next goal on the the permanency hierarchy, you have to rule out the first one. So presumptively in every child welfare case, except in certain circumstances of very serious child abuse, and I'll discuss later, reunification is the first permanency goal for a child. And usually for the first 15 months or so, reunification is the goal in the case that everyone is working towards. But at some point, we can rule out reunification. And according to ASFA, we can presumptively rule out reunification at the 15-month point, once the child has been in foster care for 15 months. Once we rule out reunification, we have to go down to adoption. And we can only get further down this hierarchy if we can find some reason to rule out adoption. When I say rule out is done according to the best interest of the child. So if for some reason adoption is not in the best interest of the child, then the court can consider permanent guardianship, or some states call it permanent legal custody. If for some reason we rule that one out, then we can go down to placement with a fit and willing relative. But this is a very strict hierarchy that presumes that if reunification cannot happen, the best outcome for the child is to be adopted. And as you know, in most states, adoption means a permanent severance of the parent's rights to the child. Some states have kind of looser open adoption laws. We have a very limited provision for post-adoption contact between a parent and a child, but it's very hard to get. In most of our child welfare system, adoptions are closed. So if we rule out if we rule out reunification and move to adoption, we're also ruling out the possibility of a relationship between the parent and the child in the future. So ASFA, as I said, we kind of go down this permanency hierarchy. So ASFA presumptively has us rule out reunification at 15 months. There's also a way to rule out reunification at the beginning of a case. And that's in cases of very serious, generally in cases of very serious child abuse. So for moms who may have helped murder a sibling, who have caused very serious sexual abuse to their child, have caused very serious physical abuse to their child, the court does have discretion to rule out reunification as a goal right up at the front of the case. One thing that I think is really interesting and kind of complex, I wish I had time to get into it more, is a very interesting policy choice. We also decided that we can rule out reunification at the beginning of a case if the parent had ever had their rights to another child involuntarily terminated. So if mom 5 years ago had her rights involuntarily terminated to child A and child A was adopted, if child B mom's next child then comes into the child welfare system, our law says, ASFA says that we don't have to provide this mom efforts to reunify with child B. We can just move directly to having child B adopted. So that was a very kind of dramatic and controversial policy choice that ASFA made. The rest of the kind of aggravated circumstances that you see here that allow children and youth to move directly to adoption instead of pursuing reunification are probably exactly what you would expect, very serious crimes against a child. Also, I should say, ASFA left open the door to states defining their own aggravated circumstances. So states may come up with other reasons that they are going to rule out reunification right at the beginning of a case and try to have a child adopted. So I wanted to kind of talk briefly about what ASFA has done. So ASFA was a law that did not include any kind of policy considerations or really any goal of addressing the unique situation of children of incarcerated parents. In general, children of incarcerated parents haven't been recognized by the child welfare system as a population with very special needs or very special challenges, but the reality is the ASFA timeline made reunification uniquely challenging for incarcerated parents and really made children of incarcerated parents very uniquely vulnerable to the permanent loss of their parent and uniquely vulnerable to adoption. So the challenges include, and I think these are probably very intuitive to most of you, achieving reunification within 15 months. If we're saying that we have to sever parental rights when a child has been in foster care for 15 months, it's very difficult to square that with very lengthy sentences that we're seeing. The average sentence of an incarcerated parent, and this is in a state facility, is 80 to 100 months. Very challenging for parents to meet that 15-month deadline. Also providing reasonable reunification efforts within 15 months. The law says that when the goal is reunification, and we'll talk about this a little more later, the Child Welfare Agency has an obligation to make reasonable efforts toward reunification. And reasonable efforts mean efforts that support that goal by supporting that parent in becoming available to reunify with that child. And a lot of jails and prisons simply don't have the kind of programming that child welfare needs the parent to complete in order to successfully reunify with that child. For instance, many of my clients who are child welfare involved have goals that they've been given by child welfare, like completing a parenting class, completing anger management, completing a drug and alcohol program, completing domestic violence counseling. Some facilities have these available and some don't. It's very difficult to get the parents these services uniformly while they're behind bars. And then I think this is one of the most troubling challenges of child welfare involvement is providing regular visits. So we know that regular visitation is the single most important predictor of successful reunification. Parents who regularly visit with their children are way more likely to reunify than all other parents. And yet, parents who are incarcerated do not visit with their children on a regular basis. We know that most parents are incarcerated at a very difficult distance from their families. So my experience has been that child welfare agencies are not providing the same kind of regular visitation that parents who are not incarcerated receive. And then I think it's really important to kind of think about the policy impact of ASFA. I think that while ASFA was not passed with any intent to impact children of incarcerated parents or to directly penalize children of incarcerated parents, it's really important to think about the time that ASFA was passed. ASFA was passed at the same time that we were enacting harsher and harsher criminal penalties for drugs. So ASFA kind of collided with our war on drugs and what I call a perfect storm of unintended consequences. ASFA did not intend to make reunification harder for incarcerated parents. It didn't intend to make children of incarcerated parents lose their parents forever due solely to incarceration, but in fact that's what has happened. So ASFA was passed when we were experiencing this very dramatic increase in how we use incarceration. From 1972 to 2011, our state prison population increased more than 700%. So as I said before, we are now the world's leading jailer. We incarcerate more of our citizens than any other country in the world. And this is largely due to the war on drugs and new sentencing policies and new criminal justice policies around that. So at the same time we were kind of incarcerating more and more people, we were also saying we're going to keep those people in jail longer. And as you know, longer is really bad when you look at the ASFA timeline, right? We only have 15 months under ASFA, but we're also going to be increasing the time that parents are spending in jail under our criminal justice policies. So mandatory minimum sentencing trends have been a huge thing. In the 90s, we saw lots and lots of laws around mandatory minimums, especially for drug offenses. So in 2009, the average offender served an average 36% longer jail sentence than offenders released in 1990. So I think the result is not surprising. As I said, I don't think there was any particular intent to accomplish this result, but the reality is ASFA made children of incarcerated parents uniquely vulnerable to losing their parents forever. And one study, again, we're keeping terrible data on this issue, but one study estimated that the 5 years after ASFA was enacted saw a 250% increase in termination of parental rights for incarcerated parents. So the Fostering Connections Act, which is also federal legislation, also is another federal law that actually didn't explicitly consider incarceration, parental incarceration, and the impact on children. But I kind of see it as a really important federal law because I think it was a little sigh of relief for these children. It was a little bit of an amelioration of the really negative impacts that ASFA had on these kids. So the key provision of the Fostering Connections, and again, Fostering Connections is another federal act that has been adopted by all 50 states. The key provisions of Fostering Connections are really sometimes very helpful to incarcerated parents and their children. So one is relative notification when a child is removed. The Fostering Connections Act requires children and youth to actively seek relatives who might be able to take the child and care for the child during the child's stay in foster care. Flexibility in foster care licensing for relatives, I think this is really, really important. I have a number of cases where my clients have benefited from this. In some states, there are very strict foster care licensing requirements about, for instance, the number of rooms in a house, the number of beds per room, things that are really not safety issues for kids, but are really kind of general well-being issues for kids that were really preventing families who were willing and able to care for children from qualifying as foster parents. So there's some non-safety kind of flexibility now in foster care licensing for relatives. And then also the Fostering Connections Act provided for subsidized guardianship. As we discussed, I showed you that the permanency hierarchy, and I showed you that reunification was first, adoption was second, and guardianship was the third option. And a lot of relatives were not able to take guardianship because they needed a subsidy to care for the children long term. Now that subsidy in many states is available as a result of the Fostering Connections Act. So the Fostering Connections Act was really good for kids because it encouraged relative placement. As I said, all those provisions that the Fostering Connections Act included that I just described really helped encourage relative placements, and relative placements are really good for kids, right? We know data is very clear that children who live in kinship placement with relatives are much more likely to stay in one place, and we know placement stability is incredibly important for kids. Outcomes for kids who endure multiple placements during their stay in foster care are very bad. So placement stability is an excellent result for kids. It also eases the trauma of separation from the parent because the child gets to go live with somebody they know, hopefully. We know that living with a relative is associated with fewer behavioral problems, and it also makes reunifications better when they do happen. When children leave kinship placement to go live with mom or dad, they're more likely to stay there and do well. And then finally, more flexible permanency options. When kids are with relatives, they don't necessarily have to be adopted. They can stay with their relatives, but also have the option for ongoing lifelong contact with their mom and dad through permanent guardianship. As we discussed, adoption is really a closed option in our system, whereas permanent guardianship is very often an open option in our system, where children retain the right to kind of contact mom or dad, have a relationship with mom or dad, and sometimes to even go back to mom or dad's custody where mom or dad is ready. So these are really good things that introduce some kind of flexibility for kids, and I was very happy to see this. Again, our policy, by and large, just ignores children of incarcerated parents, but it's nice to see this policy, and I think it could really benefit some of our clients who are incarcerated and trying to figure out the best plan for their child who may be in foster care. So I'm going to go through this case example, and I think we have time to hear from some of you on this. So I'm going to go through this case example and let some of you respond to these questions. So I made this case example up, but I have to say this is the kind of case that I see every day in my practice. So Melissa lives with her 2-year-old son, Justin. She calls the police in the middle of a violent argument with her boyfriend. The police arrest the boyfriend, but also upon spotting cocaine in the home, arrest Melissa on charges of possession with intent to distribute. At the time of the arrest, Melissa's mother, Dorothy, agrees to care for Justin. Dorothy is elderly and ailing and quickly becomes overwhelmed caring for Melissa. Melissa's sister, Stacy, is willing to care for Justin, but is struggling financially and can't afford to take on another child. Dorothy calls Children and Youth, which places Justin in foster care. And for the purposes of this example, the father is not in the picture. So what should Melissa know about the impact of ASFA on her case? What should she know about the impact of the Fostering Connections Act on her case? And I'm going to take a minute and let some of you respond to this before I go on. So I can just take a minute and hear from some of you about this.
And she means by typing that into the chat box, okay?
Oh, yeah, I'm sorry. Type it into the chat box. You can't talk. You're all on mute. So this, I imagine a lot of you are directly, I'll put the case slide back up. I imagine a lot of you are directly working with moms who are becoming involved with child welfare, either as a result of domestic violence or as a result of some other circumstances that come out of domestic violence. And I'm interested to hear kind of what would you advise this mom? What does she need to know right now about what the federal law says about her life? Anybody? Okay. Somebody posted, yes. Everybody is posting, and I thank you for this. And I think this is the most important thing that we should all make sure our clients are aware of, that there is a time limit for her. She is under a 15-month clock, and that clock starts now. It starts the minute that Justin goes into foster care. It doesn't matter that she's not sentenced. It doesn't matter that she's not tried. It doesn't matter that our criminal justice system has a presumption that she's innocent until proven guilty. None of that matters in the context of the child welfare system. There's not an exception to the 15 out of 22 month rule for, hey, mom is innocent, she didn't do it, right? So I think it's really critical that we all advise our clients, even if they're innocent, even if they're untried, even if they are unsentenced, that the 15 out of 22-month timeline is applying to them right now. So I want to go through some of your other questions, but absolutely, and I think one thing that I have been glad to see working with clients is that the word is getting out about ASFA, that ASFA means you have 15 months and that's it, except in circumstances where an exception exists. So it's really important that clients know that right up front. So somebody else said that there is support for the aunt, and I think that's really, really critical, right? So Stacy in the situation is saying, I can't care for Justin because I can't afford to do that, but if she could qualify as a foster parent, she would get a monthly stipend. So Stacy may be a resource for Justin. Somebody said also in their state this timeline is less than 15 months. Absolutely. It's important to know in your own state, as I said, ASFA just kind of sets the outside standards for 15 months. It allows states to be much more draconian. So I know, like I said, I know some states that have 6-month timelines. It's really important to know your own state's timeline on this issue. And then somebody also mentioned that she should know that she and her family can use a subsidized guardianship option to avoid the TPR check, and that's true. As I said, it depends on your state's law. In most, ASFA does say that placement with a relative can be an exception to termination of parental rights. So if Melissa can get Justin placed with Stacy, she might be able to avoid her termination of parental rights. However, for instance, in my county in Pennsylvania, we have a presumption that even if a child is living with a relative, we're going to file TPR petitions on any child who's under 6. So every state has their own law, every county has their own policy, so it's really important to kind of know, is getting this child with a relative really going to prevent TPR for your client? It may or it may not. In any event, in general, kids do better with relatives, so we want to encourage that. So I'm just going to go over this, and you guys kind of hit most of them.
Kathleen,
yeah.
This is Sue. Sorry to interrupt, but I think you said it, but could you say again what TPR is, please?
I'm sorry. TPR is termination of parental rights, and termination of parental rights is the prerequisite, the first step to adoption. So when we terminate parental rights, we take away all the parents' rights to care, to the care and custody of their own children. And the goal of TPR, the goal of terminating parental rights, is to free a child legally to be adopted and be part of a new family. So Melissa should know she doesn't have a lot of time, right? As I said, the minute Justin enters foster care, the clock starts ticking. And it ticks no matter what happens in her criminal justice case. And she should know that maybe if she can get the child with a relative, if her sister Stacy can care for Justin, that she may avoid TPR, or if she could later down the road prove that Children and Youth didn't provide reunification efforts or that termination of parental rights is not in the child's best interest, ASFA may apply. But one thing that I kind of always counsel my clients about the ASFA exception is that you never know for sure if an exception is going to be deemed to apply in your case. In general, that is a call that the judge makes. So you can never presume that you're safe from TPR because you have an ASFA exception in your case. The impact of fostering connection. So Melissa should know that the law absolutely prioritizes placing children with relatives. Federal law is very clear. DHS has to first try placing children with relatives. They have to explore whether there are any relatives who are able to care for the child as a kinship provider. So, and that part of fostering connections is that all the relatives in the case should be sent written notification that, hey, there's a child here that you're related to that is entering foster care. If you're interested in being a resource for this child, let us know right away. So all known relatives will be notified, and any relative who's willing should contact Children and Youth immediately. So if Melissa knows of other relatives who might be willing to take Justin, she should let them know immediately, hey, contact my Children and Youth worker, let them know you're available. She should also contact her Children and Youth worker immediately to let them know, hey, I have this relative. The law requires children and youth to notify relatives, but they can only notify relatives that they're aware of, right? So while a number of states have done a really good job of implementing kind of family finding policies where they actively look for relatives, not every state does a good job of that. So it'll be really important for Melissa to kind of get in touch with her children and youth worker and say, here are the relatives that might be able to take Justin. And again, Stacy, her sister Stacy, should know that she might be eligible to be a kinship provider even if she doesn't meet foster care licensing requirements, because the law now provides that there's some flexibility there. If there's non-safety reasons that Stacy couldn't meet a foster care licensing requirement, that could possibly be waived. So these are laws that actually impact every single state, but don't actually address parental incarceration and how parental incarceration plays into the child welfare case. As I said, ASFA is totally silent on incarcerated parents and children of incarcerated parents. The Fostering Connections Act is totally silent on incarcerated parents and children of incarcerated parents. But some states have worked out their own statutory frameworks and do specifically address what we do with children of incarcerated parents and how the ASFA timelines might impact those families. So it's really important to be aware of how different states are handling this. And I'm so excited there are so many of you from across the country, and unfortunately I couldn't address what every state does, so I'm kind of giving you general broad strokes on how most states handle different issues. So these are the issues that I think are on the table. Some states address them specifically in their statute. Some states address these in case law, which is opinions by judges which are interpreting the statute. And some just don't address these questions at all, and it's up to the individual trial court judge. But I think the kind of the hot topics in dealing with these families are, do incarcerated parents get reasonable efforts? As we said, in general, under federal law, parents are entitled to reasonable efforts to support them reunifying with their child. But does that guarantee extend to incarcerated parents? What are those efforts? If we are saying parents get efforts from children and youth to reunify with a child, what are those efforts? What do they look like? What is children and youth required to do for the incarcerated parent? How does incarceration factor into the grounds for termination of parental rights? I think a big question that a lot of states struggle with is incarceration alone enough to terminate parental rights? What do you do when you have a mom behind bars who's doing everything she possibly can to reunify with her child, and yet she's incarcerated? Is it okay to terminate her parental rights? And then another question under ASFA that ASFA kind of left unanswered is, we have these exceptions to the requirement that we terminate parental rights after 15 months, but this exception of a compelling reason not to file a termination of parental rights, what is that? What is the compelling reason that it's not in the child's best interest to file PPR petitions? Can parental incarceration be a compelling reason? These are kind of things that are left unanswered, but I'm going to go through with you what the states say about them. So what are reasonable efforts? I think this is a really interesting question, and if there are any caseworkers here today, I sympathize with you, because you're being told that you have to do reasonable efforts, but you're also being told that we're not going to define what that is. So the federal government has specifically declined to define reasonable efforts. There is language in the federal code requiring that children and youth workers make reasonable efforts to reunify a parent with a child, but the feds actually specifically said, we're not going to tell you what that is. So states have defined reasonable efforts in their own way. Some states, like my state, does not in its statute define what reasonable efforts are. Other states do. Most states don't even say what reasonable efforts are. So are incarcerated parents entitled to reasonable efforts for reunification? In most states, yes. In most states, there's no exception to the requirement that children and youth provide reasonable efforts towards reunification. In most states, they still are under that federal requirement that they provide reasonable efforts to reunify each and every family in the child welfare system. But you should be aware that in a couple of states, the fact that a parent is incarcerated alone can be an aggravated circumstance, which means that children and youth does not have to offer reasonable efforts and actually can move down the permanency hierarchy directly from reunification directly to adoption in cases of an incarcerated parent. Just a few states do that, but it's a very draconian rule that you should be aware of if that's your state. What are reasonable efforts for an incarcerated parent? Again, as I said, the feds aren't defining this for us, so we've left it to the states to define what reasonable efforts are. The vast majority of states do not define what reasonable efforts are for an incarcerated parent in their statute. Some define more generally what are reasonable efforts in their statute without specifically identifying the issues relating to incarcerated parents. But in general, I think these are kind of the bare minimum, supporting the parent-child relationship through visits, letters, and phone calls. As we discussed before, it's very clear that regular visitation is the best predictor we have right now of successful reunification. If visits and contact aren't happening, very unlikely that reunification is going to happen. Involving the parent in case planning. Involving the parent in case planning is actually a requirement in the federal statute. So every parent must be involved in case planning. That is universal, and there is no exception for incarcerated parents absent aggravated circumstances. Keeping the parent informed about what's going on with their child, what's going on with their case, and supporting the parent as they complete the case plan goals that they can in jail and as they transition back into the community after incarceration. I think these are kind of the bare minimum reasonable efforts that would be supported by the law. So New York, in all things incarcerated parents, is my model. California does a very good job too. There are a couple of states right now that are really starting to look at these kids and really look at the impact that our laws have on these kids and have really introduced into their state statute very comprehensive understandings of what reasonable efforts are for children of incarcerated parents. So New York does it and California does it. And I include this statute here for you just so you can see how New York has interpreted what reasonable efforts are to these families. So involving the parent in developing the service plan for their family, visitation, support, keeping the parent informed, informing the parent about their legal rights and obligations, which means absolutely telling them about ASFA, providing the parent with information about services in the community to support their reentry. So New York has a really great statute. If anybody's interested, I can send you more about their law. They kind of rewrote their law around children of incarcerated parents in 2010 and did amazing things, and I think that they're a model for the rest of the country. So this is a really interesting question. Can parental incarceration be a compelling reason not to file to terminate parental rights? So we know that, as we discussed, there are 3 ASFA exceptions. There are 3 exceptions to the 15 out of 22-month rule that DHS has to file to terminate parental rights after 15 months of a child being in foster care. As we discussed, one of those is the child is living with a relative. Another is children and youth provided inadequate services to the family. And then the third one, and I think one of the most ambiguous ones, is there's a compelling reason that it's not in the child's best interest to terminate parental rights. And what the heck is a compelling reason? Well, again, the feds decided not to tell us. So we are left, there's very limited guidance in the code that says in some circumstances if adoption's not appropriate, but really didn't give us very strong guidance at all about what could be a compelling reason not to file to terminate parental rights. And could parental incarceration be one of those reasons? So most states, again, don't define it. A few states do make parental incarceration a compelling reason not to file TPR. Again, I looked to New York, and actually, I should note that Washington State last month passed legislation also making parental incarceration a compelling reason not to file TPR. Every state that does this, I didn't put this statute up for these, but every state that does this really looks at the best interest of the child and the efforts that the parent has been making from jail, where the parent has really been reaching out to the child, working harder on their family service plan goals, staying in communication with the child, and it's really not in the child's best interest to sever that parent-child relationship. parental incarceration may be a compelling reason not to file TPR. So my guides for that are New York and Washington. They have wonderful statutes right now. I'm hoping more and more states will start to look at this and consider putting this into their statutes. And I should note, for any of you who are in Pennsylvania right now, there's current legislation pending in our state Senate actually doing just this, making parental incarceration a compelling reason not to file TPR consistent with the best interest of the child. This is a really thorny question. Is the fact of parental incarceration alone enough to terminate parental rights? So ASFA doesn't address this, of course. ASFA is very quiet on incarcerated parents, so we don't know from federal law whether incarceration could be a ground to terminate parental rights. And there are three major trends in the law right now. One is that, yes, incarceration alone is a ground for termination of parental rights. A lot of states, I would guess around half of the states, have actually put this into their statute, have actually said a parent who has a sentence of 2 years or more, that would be enough to terminate parents' rights regardless of the effort the parent makes from jail. Others really have a kind of multifaceted approach where they look at all different factors, and incarceration is just one factor that can be considered. So it's not the only factor. It's among many. It's not necessarily a determinative factor, but it's an important factor. A lot of other states have that kind of approach where they specifically look at incarceration in their statute. Another approach is a lot of states in their case law or in their statute explicitly, but often more often in case law interpreting their statute, hold that incarceration alone is not sufficient to terminate parental rights. You have to establish some other kind of evidence of parental unfitness aside from incarceration in order to terminate parental rights. I would say that's the minority jurisdiction. Most states allow some form of termination of parental rights due to incarceration, but there are some states that say in their case law consistently and repeatedly, incarceration alone is not sufficient to terminate parental rights. Again, I give you New York statute because I think it's so great. So it does provide an exception, as I said, to the 15 to 22-month filing requirement where the parent is incarcerated and has maintained a meaningful role in the child's life. And I think this is really interesting. It requires the court, in determining whether to terminate parental rights, it doesn't say that incarceration is a bar to terminating parental rights. You certainly could terminate the parental rights of an incarcerated parent, but if you're going to do it, you have to consider the special circumstances and barriers faced by an incarcerated parent. If child welfare has given mom a goal of completing parenting classes and she hasn't met that goal, well, are there parenting classes available in the jail? What did mom do to get on the waiting list, if there are available? Things like that. The court really has to kind of look at the totality of the circumstances and the really particular circumstances of this mom's experience while she's incarcerated. And then when we say that we shouldn't TPR after 15 months where the parent has maintained a meaningful role, the statute actually explicitly defines what is a meaningful role in the child's life. And that is really reaching out to the child first and foremost, but also working with children and youth on trying to reach their service goals, trying to plan for the child. And also the court has to inquire, is a continued relationship with his parent really what's in the child's best interest? So New York has taken a very comprehensive approach to this question and really thought very carefully about in what circumstances are we going to terminate a parent's rights due to incarceration, and what factors are we going to consider. So that is most of the law that I'm going over, but I want to make sure, I know I threw a ton of law at you at once, and I want to make sure I'm taking a few minutes to answer questions. So if I could kind of just take a few minutes and you can type questions into the chat box. I might not be able to get to every one, but I wanted, before we start going over our case example, which I'll go back before we get there, I have 2 more case examples that I wanted to discuss with you. Before we go there, I just want to make sure I'm answering all the questions. I know it's complex to look at all these laws at once.
You've done a great job on explaining them. This is Sue O. We have a bunch of questions already. I'm just not. I mean, do you want them now, or do you want to go a little further? I
can because this is the end of my description of all the laws. And now I'm going to kind of go into kind of policy and advice for parents. I can just take a few minutes and make sure that I'm answering some of the legal questions and about what the statutes say, just for like 5 minutes or so. I'll just try to get to as many as I can, if that's okay.
Sure. It's a number of the questions are asking for like lists of the states that do this or do that. Is there a resource that outlines by state the things that you're talking about today?
Yes, there is. So it might be a few years outdated. In the late part of the last decade, like I think it was like 2009 or 2010 maybe, an attorney from the ABA working with another author examined every single TPR statute in the country and looked at how they factor in parental incarceration. And there's a wonderful chart. It's very nice. I don't know if I can send that to you at some point, or
if you send it to me, we can send it out to the people, the link out to the people, and or we can post it on Google Docs.
Great. So I will make a note to get that to Sue within the next day or two, because it really is wonderful. It's a very lengthy document that kind of goes over how every single state considers parental incarceration when they look at TPR.
And you also mentioned New York State a number of times, and you said that you could share that information. That if you can send it to me, we'll also put that up on Google Docs so everybody can have access to that, if that's all right.
I'll send you the New York's legislation?
Yeah.
Yeah, absolutely.
That would be great. One of the early questions came up, and let me just read it to you, because you addressed it a bit, but I think she brings up a really important point here. She asked, will we address the disproportionate way in which these laws affect people of color, specifically African American parents, due to the fact that the war on drugs impacted our communities at a much higher rate, due to the issue of disproportionate prosecution rates of African Americans, especially with the difference of sentencing powder cocaine versus crack cocaine?
I mean, amen. I think that it's a really, really critical point, because we know that children who are African American who enter the foster care system who don't have an incarcerated parent are disproportionately impacted. We know that children who are white are more likely to be left in their homes than children who are black. We put children who are black in foster care at way higher rates, even when the allegations are virtually identical. So children who are black are way more likely to end up in foster care than children who are white. Anybody who's interested in research on this should really look at the work of Dorothy Roberts, who's a professor right now at the University of Pennsylvania and has done wonderful work on what we call racial disproportionality. So I think we already know that African American children are way more vulnerable to entering the child welfare system. And then when we incarcerate all their moms, we make it even more likely that they're going to enter the child welfare system. I wish I had a solution to this, but absolutely it impacts communities of color way more than it impacts the general population. I wish I had an idea of how to get at this. Maybe somebody could bring a civil rights suit. I don't know. But it's a really important point.
Indeed. I mean, some of these are broader policy and research questions, so I don't know if you want them now. So maybe I should just go forward. Yes? No?
Yeah, and then we'll have.
Okay.
So we still have 20 minutes, so we'll have more time at the end to kind of talk about some of the questions.
Gail Smith, who is a longtime activist who has worked with incarcerated mothers for a long time in Chicago, asked a number of good questions. And so let me pose all three of the ones that I have right now to you, if that's okay. One is, do you have research or resources demonstrating the benefits of family placement? Gail says it resonates with her experience, but it's always helpful to have to be able to point to research. That's one of them. The next one was any efforts in Pennsylvania to toll the clock for incarcerated moms. And I think she asked a really important question: is that something you think we could push federally? And then the last one is, do you know a good example of a reasonable efforts definition that may have been asked before you put up the New York State statute? And then also she had a question about model legislation.
Okay, great. So I'm going to start with first the issue about research of benefits of family placement. So there was actually a lot of work around that issue when the Fostering Connections Act was passed in 2008. And I can send you something, Sue, after this. The Child Welfare Information Gateway is a website that I very highly recommend. It's just childwelfare.gov. They do a really great job of not only collecting state laws, but also kind of research around child welfare and what we know. So they have gathered some of the research about the benefits of kinship placements for kids, and that was the research that is out there was a really large driver of the Fostering Connections Act. So I can send you a link. I think they have one or two issue briefs on that I can send you, Sue, if that's helpful.
That would be great.
So the next question, I think, was, have there been efforts to toll the clock for incarcerated moms in Pennsylvania? Is that the question?
That is.
Okay. So in Pennsylvania right now, there is legislation pending. It would not necessarily toll the clock, but it would do two things. It would say that it would change our adoption statute to say that incarceration alone is not grounds to terminate a mother's rights. And then the other piece of legislation that's pending in our legislature right now says that it's very similar to New York's legislation, and it says that parental incarceration may be an exception to the 15 out of 22-month rule consistent with the best interest of the child. So in some cases you may say, okay, mom has a 3-year sentence, but she has a very strong relationship with her child. It's going to devastate this child to terminate parental rights. We're not going to do it. So those two pieces of legislation are sitting in our Senate right now. They were actually the byproduct of a Joint State Government Commission report that was issued in 2011. I'd be happy to share that with any of you. I was a member. It was a statewide task force that reported to the legislature on children of incarcerated parents in Pennsylvania, and one of the key recommendations of that was this legislation. So I would love to see this legislation move forward. It's sitting in our Senate right now. It hasn't had a hearing yet. The other question is, has there been a push federally to get this done? Not yet. I would love to see that done. As I said, this has been an issue that the feds have really ignored for a long time. The GAO report that came out in 2011 on children of incarcerated parents in foster care was really the first time the feds paid attention to this issue. So they're really just starting to look at it, and it's kind of, I think, the next frontier is really consideration of whether we should look at modifying ASFA to really address the unique needs of these children. But as of now, there's been no national push on that. And then the last question was about reasonable effort. Oh, that was about whether there are model statutes around reasonable efforts.
That's correct.
Again, I think New York has a model statute. I can also send you to California statute, because I think that's pretty good too. So
a couple
is that
more.
all for now?
I'm sorry?
Should I move on, or?
Sure. And,
okay.
And then there are some more questions when we have time.
We'll do it at the end.
Okay.
Okay. So I'm going to move on with our case example. So I'm going back to Melissa, who we looked at the beginning of this presentation, and she claims she's innocent. She's saying she didn't do this. This wasn't her cocaine. She didn't have an intent to distribute it. And she decides, I'm going to go to trial. I'm not going to plead guilty because I know I didn't do this. But unfortunately, due to various delays with the criminal justice system, she remains incarcerated awaiting trial for 8 months. During that entire 8 months, Justin remains in foster care. The Children and Youth Agency considered placing Justin with Stacy, but Stacy's husband has an old criminal record, so they decide against it. Melissa is very concerned about Justin and wants to reunify with him. I mentioned Stacy's husband having an old criminal record because I just wanted to flag for everybody, even if a potential parent, caregiver passes all requirements under the law to qualify as a foster parent, Children and Youth still retains discretion to not place a child there. So even if Stacy's husband has an old, for instance, simple assault charge, which is a misdemeanor, which would not really prohibit him from ever being a foster parent, Children and Youth could still decide, hey, I'm not going to place a child in that home. And I've seen that happen with parents with caregivers who have very old criminal sentences. I've seen people's criminal convictions from 20 years ago used against them. So I think it's important to be aware of that. So what services should children and youth provide to Melissa? And I'm just going to, in the interest of time, I'm going to go through some of this. This is really to illustrate kind of what I was talking about in terms of what are reasonable efforts to these families. So this, again, is Melissa. She's waiting in jail. Her son's in foster care. She doesn't know when she's getting out. And she really wants to reunify with her son. So what kind of services should children and youth provide her? In the interest of time, I'm going to tell you the answer that I think would be justified under federal law and most state law. It depends, obviously, on what her state law, but at the minimum, they should involve her in planning for her son. Again, that is absolutely the minimum. The federal government does require that parents be involved in planning for their children, and there's no exception for incarcerated parents. So at the very minimum, they have to involve her in planning for her son. They should also, though, offer her visitation. I didn't get into this a lot, but most states, a lot of states do not address visitation for incarcerated parents. Some have it as a best interest standard, so some say that children of incarcerated parents should get visits with their parent if it's in their best interest. That's what New York State has, for instance. My state actually has a much better standard for parents, which presumes that incarcerated parents are going to get visits unless there's a grave threat posed by the visits. So it's important to know what your jurisdiction is, but in general, I think the presumption should be that children and youth is going to provide visits. Visits are kind of the hallmark of reasonable efforts. They should also let Melissa know information about her child welfare case. When's her next court date? Can she have a lawyer? How to participate in court proceedings? I didn't go into this very much, but almost every state has a requirement that parents be provided a lawyer in child welfare proceedings if they can't afford them. So it's really important that she knows how to get a lawyer. They should offer Melissa support in communicating with her son. They should offer her support in meeting whatever her case plan goals are. So if they want her to get into a parenting class, they should call her counselor at the jail and let them know that she needs to be in a parenting class. Maybe she can get, like in Philadelphia, if that happened, Melissa would get priority placement in that parenting class. So what efforts should Melissa make? And I think this is really critical in how we think about how we advise our clients who are dealing with the child welfare system, because not only is the court scrutinizing the children and youth make reasonable efforts, they're also scrutinizing our client, and they're scrutinizing the efforts that they make behind bars. And I think they're doing it even more for incarcerated parents than they are for the general population. So they're going to look very carefully at what is Melissa doing while she's behind bars. So what efforts should she make? She should stay in touch with her children and youth worker. My experience, and I think probably a lot of you have the experience that children and youth workers do not attempt to communicate with incarcerated parents. But a lot of times they'll respond to correspondence that they receive. So Melissa should, if she can, send letters, see if she can make a phone call, see if she can get her worker to come meet with her, send a written request that her worker come meet with her and talk with her. As with everything, I advise my parents, the squeaky wheel gets the grease. Children and youth workers have huge caseloads. They have a lot of people they're trying to provide efforts to. The more you're kind of waving your hands in their face asking for those efforts, the more likely you are to get them. And I don't mean that as any insult to children and youth workers. I think they're way overworked. Make every possible effort to stay in touch with her son. So absolutely she needs to make it clear to her children and youth worker immediately that she wants visits. If she can't get visits, she should ask to be able to talk to her son on the phone. Even a 2-year-old can recognize mom's voice on the phone. Send cards and letters. I have a client who actually successfully reunified with her daughter. Her daughter was a really small infant, and I remember going to court, and my client, who was incarcerated, was obviously this child can't read letters, but she would draw pictures for her daughter. She would draw these really elaborate kind of Disney characters, coloring cards, coloring pictures. Even if all the child did was stick it in her mouth and chew on it, it was really significant to everyone on the case, and I think it really helped the judge see that my client was committed to reunification. Enroll in as much jail programming as possible. If there are goals on her case plan that she can complete in jail, she is way ahead of the game if she can do that before she even leaves incarceration. And it's really critical that she finds an advocate. And luckily, I think there are a lot of you out there who are advocates for these moms and can really help them navigate the child welfare system. But she also, in most states, will have a legal right to an attorney. And that attorney can really advocate for her in court. If she can come to court, she should come to court. I in Philadelphia, bring all my clients to court who are incarcerated for every single hearing. It's critical that the judge see them and hear from them. If she can't come to court, try to participate by phone. If she can't participate by phone, she should request that her attorney come meet with her and represent her position in court. Again, as I was saying with child welfare workers, the same rule applies to attorneys. The squeaky wheel gets the grease. Lots of child welfare attorneys are really inundated with cases, have way too high caseloads, have way too many clients they're trying to service at the same time. Clients who kind of put it out there right up front are more likely to get the attention. So Melissa's criminal trial occurs. She is found guilty of a lesser misdemeanor offense and is given time served, but 10 months have passed since Justin entered foster care. She's lost her job and her apartment. She desperately wants to reunify with her son, and her caseworker has told her children and youth is considering filing to terminate her parental rights, and that she will have to prove in the next 5 months that she can care for Justin, or they will have to file a petition. So Melissa has really been harmed by having spent all this time in jail. She's got obviously been separated from her son for so long, but she's also been kind of put in a position of having to start from square one in terms of building up her life again, getting housing, getting a job, finding a way to care for her son. So what efforts should she make now upon reentry? Again, she should visit with her son. The number one best predictor of successful reunification is visitation. The more you say that to your clients, the better. They should visit, and they should visit frequently. She should try to stay involved in her son's life. She should know who his doctor is, who's his teacher, if he goes to daycare. Stay in touch with those people. Know what her case plan is. She has specific goals that DHS or Children and Youth has set out for her. She needs to know what they are and how she can accomplish them. She should ask her Children and Youth worker for reasonable efforts. If there is any single goal that she's having trouble meeting within the next 5 months, she needs to reach out to her Children and Youth worker and let her Children and Youth worker know. She should also stay in touch with her attorney and make sure her attorney knows. If Children and Youth is not providing, and I think this is in response to one of the questions that somebody mentioned, what do we do if Children and Youth refuses to provide reasonable efforts to this person? If Children and Youth is not providing reasonable effort, she needs to let her attorney know so it can be brought to the attention of the court. At every single court hearing, the court has to make a determination as to whether reasonable efforts were provided. If the attorney stands silent, the court will make a determination that reasonable efforts were provided. If the attorney speaks up, maybe not, or maybe the court will force Children and Youth to offer better services. And really, I think one rule in child welfare that I found representing parents is document, document, document. Bring documentation of every single thing you do. Any certificate you receive, if you've got a house and you have a lease, bring that. So now I know we don't have a ton of time left, but I want to make sure I take some time to answer some more questions.
Thank you, Kathleen. There's so much important information. Every time one of these webinars happens, I think, we need a part 2. Well, because maybe we can actually, Kathleen, answer some of the questions. I can get them to you, and you could do some of them in writing and post them because if you already have
Sure.
those answers. So as a way, just for those of you whose questions we are unable to get to today, maybe we can get to you in that way. One of the questions, however, was, is there a process by which you can get ASFA exceptions noted or to be part of the record?
Yes. Obviously, this can be state dependent, but I, in my jurisdiction, ask the judge to note it in the court order. So as a parent's attorney, I specifically say, Judge, will you find that there is, for instance, a compelling reason not to terminate parental rights even though 15 months have passed? Or Judge, will you find that termination of parental rights is not appropriate because the child's living with a relative? I will specifically ask the judge to make that determination on the record and put it in the court order.
Great, that's really helpful. Another person asked, and I think you talked about some of the strategies, but her question specifically was, are there strategies that you can recommend to minimize the risk that incarcerated women's children will be placed in foster care so the limitations period does not begin to run right away?
Yeah, informally, before, I guess I just want to make sure this is really clear. The 15-month timeline only applies to children who are in foster or kinship care that is paid for by the county or the state. So if you're working with a client who is not yet child welfare involved, and you can work with that client to get a relative to agree to take custody of that child and provide care for that child, children and youth really doesn't have a reason to intervene. And as I showed you in my case example, for instance, children and youth really intervenes when mom hasn't made a plan that works well for her family. So if a mom is incarcerated and makes a custodial plan that is fit for her child, DHS really doesn't have any authority to intervene with that. Where they have the authority is if mom makes a bad plan, a plan that's dangerous. For instance, mom decides that a violent felon who has sexually abused the child should watch the child while she's incarcerated, so mom makes a bad plan, or in the circumstance where mom's plan falls through, right? So in the example I gave you, the caregiver became very ill and could no longer care for the child. But in general, when you're working with clients, helping them to make a good plan for their child that is going to keep the child out of child welfare involvement is the absolute best way to avoid the child welfare system. Once a child is in the child welfare system, the best way to avoid the ASFA time frame is to get the child placed with relatives quickly. Again, it doesn't guarantee that rights won't be terminated, but it helps a whole lot. So really important that if you have clients who are child welfare involved, that you are holding the child welfare agency to the requirement that they first try to place children with relatives before they place children with strangers.
That's very helpful, Kathleen. Another question is from a woman who probably is from in Oregon, and she says, in Oregon, the policy is to terminate parental rights for both parents or neither. Is that true in other states?
You know, that's such an interesting question, and actually that was a question that was raised in our Superior Court, which is our first court of appeals, just in the last 2 or 3 years, because for a long time you would only terminate on one parent if you were also going to terminate on the other. So for a long time our law required that you terminate on both, and our Superior Court said, no, you don't have to do that. You can terminate on one parent and not terminate on another parent, and that's okay. I don't know the answer how other states are dealing with that. I'd be really interested to know. To me, it doesn't make a ton of sense to terminate on one parent and not the other, because the entire purpose of termination of parental rights is to clear the path for adoption. So if you're only terminating on one parent, you're not clearing the path for adoption. So I actually thought that was a bad decision from our Superior Court. But
interesting. And I believe this question is coming from Hawaii. And the question is, what are the requirements of legal services to inform clients of their rights? I've had a number of participants who have pled guilty so that they can get children back and then are negatively impacted by that guilty plea.
Oh, geez, that's heartbreaking.
Yeah.
Yeah, I know. It's very tricky, and my clients face that all the time. I mean, attorneys have an ethical obligation to advise their clients, and criminal attorneys have an ethical obligation to advise their clients of the civil consequences of their decision to make a plea bargain. So very troubling to hear that. I'm not surprised, though. Absolutely, criminal attorneys, I think, need to be aware of the potential impact on the child welfare case when their client pleads guilty. As you know, as I showed you before, certain crimes, if a parent is convicted, that's an aggravated circumstance, which means that DHS can move directly to planning for adoption for the child. So it's really, really critical that criminal attorneys do a good job of advising clients about this. It's absolutely malpractice if they don't. I would say it's really tough for clients to be in the situation because you have the ASFA clock ticking and there's a very strong incentive to settle. My clients who know they're not, I had a client who knew she was not guilty and said, I'm going to wait for trial, and she waited for months and months, and DHS filed to terminate her parental rights. It happens all the time. so there's a very tough tension and tough decision that parents make. They want to get out as quickly as possible, so there's a strong incentive to take a plea bargain, but that plea bargain could be used against them in TPR proceedings. So really tricky.
Yeah. And before you talked about making sure that the women or the parents are documenting everything, Gail Smith added, and document communication with kids and with caseworkers. We have clients keep a log, copies when possible, even a first draft. So I just wanted to make sure that everybody saw that in the chat. Kathleen?
Yeah, that's huge. Yeah, I think that's a huge point. We advise our clients to kind of keep a notebook and write down everything that they do. And it's hard for clients behind bars to make copies of the letters that they send sometimes, but sometimes my clients who are incarcerated locally can go into the jail library and make a copy of whatever they're sending to their DHS worker, and I encourage them to do that. Documentation ends up being so critical in these cases.
Well, just to honor people's busy schedules, including yours, Kathleen, I do want to close this webinar and really thank you for this incredible presentation. It was so clear. It was so depressing. And it was so filled with information that people need to know. And it was just laid out really well. So I really appreciate it. To those of you who have been listening in, we will try to get as many of those documents up on the Google Doc link as soon as possible. And so you might want to check back that you got the link to that Google Doc site this morning, and it will also be in the follow-up email. Katita also just put it back in the chat box. And Kathleen, any last comments before we hang up?
Yeah, I just want to mention the last slide of this presentation is my contact information. I hope you can tell by now that I'm really passionate about this issue and I really want to help incarcerated moms. If you have a specific question or anything specific I can help with, you can feel free to use this contact information to get directly in contact with me.
And while I said the information was depressing, I do want to say how invigorating and exciting it is to have advocates like you, Kathleen, working on this topic. Seriously, it's you and other people who have been fighting so hard for the rights of incarcerated parents and have made a difference. And so thank you. So I don't want to end on a downer note that the information is depressing, but the activism and smarts and creativity of people like you really makes a huge difference. So thank you for informing all of us of this very important information. And maybe we really can think about a part 2 about so now what? And what can people do? So it was terrific. So thank you, and thank you to everybody who's participating. I'll keep the little chat box up so you can write nice things about Kathleen in there. And also we will be sending out a message, and it'll come in about a half an hour. There's a very short, it's a 4-question survey evaluation. It's just really helpful if you respond to it. It really will take probably 2 minutes of your time. So if you could do that, that would be terrific. So thank you, and thank you so much, Kathleen. That was terrific.
Great, thank you.
Okay, bye, everybody. I'll keep the webinar system up for about another 2 minutes, and then I'm going to sign out, and then we'll disconnect you all. Okay, thank you. Bye-bye.